I placed a claim, or I started a claim, and I didn't realize that you also have to make the orders and place them at the same time that you make the claim, or that you file your claim in court or at the courthouse. And I was wondering if it's too late to put your order in, or can you just put your order in when you go to court, or how does that work?
Can I give an answer? Did you have it served already?
Yes.
How many
the Attorney
how many
General,
words are on your? How many? This is Mark in Atlanta. I've personally made a claim. I haven't had it served yet, but you had it served already?
Yes, I did.
And it doesn't have anything at the bottom as far as what you're ordering, what you want. What are the elements of your claim?
Well, my claim, the way I worded it was that, let's say Bridget trespassed upon my property by way of theft, that she's a wrongdoer and that she administrates my property without my consent. And at the end of it, I put that I require the immediate restore of property. But I didn't.
That's your order then. Yeah, you got your order right there. That's it.
Okay.
Can I jump in, Mark? I want to share something that you taught me, actually.
Go ahead.
Yeah, when you served it, how did you serve it? Because you don't want to serve it in a way that jeopardizes.
No, I had a service. What do they call them? A process server. Serve her with the paperwork.
Did you serve it to her in her name as a woman or as an officer or an agent?
As a woman.
Okay. Good. I got a question. The process server, what kind of paper did she give back to you? How does that read?
I got an affidavit stating that at a specific time, this woman was served.
That first word you use began with an A, affidavit.
Yeah. Well, what I had done was I had made up my own notice, kind of similar to what Karl had done up for court. And so I served that on the courthouse, and the courthouse sent it back to me stating that I wasn't following civil procedure rules. But the crazy part is that they returned it back to me, but in the meantime, because she's a social worker, the Attorney General jumped in and served me with paperwork and had a court date set up. So I don't really understand how an Attorney General can step in and have a court date set up when they sent me back all the paperwork stating that I wasn't following civil procedure rules, and as far as they were concerned, that I hadn't served her properly. So I don't know how that all works.
Well, first of all, that's good that they told you weren't following civil procedures.
Right.
You're not trying to.
Right.
So that's great. You just got confirmation from the court that you're in common law.
Okay.
So plus
I guess that's one way of looking at it.
Yeah, well, that's his opinion. He's entitled to his opinion.
Right.
You know, you don't want to argue with that.
The only thing is that
what you want to look at is, did you do anything that they could interpret as traversing? You know, did you fill out their cover sheet? Is their civil cover sheet?
I'm in Canada, so it works a little bit differently here because Karl's always said that because we have the English common law here, that you still have to fill out their paperwork. But what I did do on the second, because I modified my claim a few times because I wasn't quite sure exactly what I was doing, but the second time when I modified my claim, I did put on the form that I was doing it strictly for the ease of the Court of Clerks filing practices only. Perfect. And that was one of the disclaimers that I had on another one, or actually I tried to start another claim because I thought the first one was all messed up. And they came back and told me that I couldn't put that disclaimer on there. But when I went back and did the original claim, which I had gotten through and gotten a case file number for, they screwed up and somehow let my modification of the original claim go through. So at least I left out on that part where I've got the disclaimer stating that I'm actually filing a claim and not a complaint.
Did you go into the form and change the words like plaintiff to prosecutor and defendant? You changed to wrongdoer and get rid of it?
Because they told me they wouldn't allow me to do that. But what I did do was in the description where you put your name, I did put an aggrieved woman, and I put that I was a prosecutor, and for the wrongdoer, I did actually put wrongdoer, but I still had to leave defendant and plaintiff on the form, or otherwise they wouldn't accept it.
Yeah, they did that to me, so I just said I need the bond of the man or woman who's obstructing me from doing my filing. And I only had to say that once, and I said it very nicely. I didn't say it in a threatening way. I just need to know who's obstructing me from filing my case in common law. And that was after that they all backed off, and they waited till the head clerk came in. So it's one of those things you just got to persist on. They have to take it. Mark's living proof. I'm living proof. Other people who've gotten their claims in. They're just going to test your mettle. That's all.
Well, I've gone so far as even contacting the Chief Justice for the Supreme Court of Nova Scotia, and unfortunately I handled that letter incorrectly because I was kind of showing that I was in their, or understanding their legalese, when actually what I should have done was they had written me a letter stating that as soon as I accept or start working with their civil procedure rules as a litigant and whatever, that they would allow me to go into the courts and use their facilities, let's say. And what I ended up doing was I wrote back and I said that I'm not a litigant, I'm not a plaintiff, I'm not any of these things. So basically what I was saying in my letter was that I understood exactly what legalese BS they were trying to explain to me or send to me, and that's where I kind of messed up with the Chief Justice. Yeah,
that's okay. That's still redeemable. But the key is you understand you're not going in their court, right?
Yeah.
You're at their court, but you're in your court.
Right.
So, if the person's last name, if someone's name is John Doe, then it's going to be you're in Doe Court. You're not in Superior Court. You're not in, Queens Court or whatever the name of their court is. You're in your last name court.
Right.
At the physical building, whatever the name of that court is.
Right. And
do they see that on your paperwork?
On everything that I've done.
Okay, that sounds good.
But they're still, for the longest time, they weren't even accepting any of my paperwork. They were sending it all back to me. And then what I ended up doing was getting the postmistress to stamp the postage or her date stamp onto everything. And ever since I started getting her to do that, none of my paperwork has been coming back because they've been refusing to accept my paperwork for my claim, for my file at the courthouse.
Could you repeat that? What you just said? What the tactic that you're using?
Okay. What I did was I noticed that one time when I got the I don't know if you call it postmistress or postal clerk or whatever, I got her to stamp her date stamp onto my paperwork, and every other time before I had that done, my paperwork always got sent back to me stating that they couldn't accept it because it wasn't in the civil procedure rules or following the civil procedure rules. But this one time when I got it stamped by the postal clerk, it didn't come back. So ever since then, I've been getting everything stamped by her first before I send it into the courthouse, and nothing ever comes back when I end up doing that.
I had the same experience. That's why I asked you to repeat it. And what's happening is you just made the postmaster your witness.
Yeah, but John, the postal stamp that's being put on this paperwork, it's being put on the actual filings, the actual papers that are going to be recorded into the case?
No.
Yes.
Yeah, it sounds like she's having the postal worker timestamp the actual filings, not the envelope itself, the actual filings.
No, she's canceling not that. She's canceling not the letter. And whereas the postal service have jurisdiction. post
Barbara,
office jurisdiction.
But Barbara, are they putting a timestamp on your paperwork?
Yeah.
Not
at the
on the
courthouse.
outside of the envelope?
No, at the courthouse, they will not stamp anything because when I get things returned back to me, there's no stamp that actually shows that the courthouse has ever received it or gotten it, even though I sent it their registered mail. But I did notice they made one mistake one time of sending me the envelope back that I had mailed things in to there, and they did stamp the envelope, but they wouldn't stamp.
Barbara, let me ask you this. What he's asking is, okay, let's say you had 5 pieces of paper that you were mailing.
Right.
So did they postmark those 5 pieces of paper, or did they postmark the envelope that you was mailing it in?
The post office clerk was stamping. I got her to stamp every one of my pieces of paper that I was sending in.
Okay.
So if I had 5 pieces.
Okay, good. So what that means is the post office had, in other words, you took the jurisdiction away from the courts, and the Postal Service got pure jurisdiction over it. So that means that it's got to be accepted.
Larry, how familiar are you with the post office being the court of original jurisdiction?
How? Repeat that again. How? What now?
The very first thing ever established in the United States on the land was the post office. The post office was the courthouse. It was everything.
Exactly.
And I believe that what Barbara's doing by getting the post office to stamp each one of her papers, she's putting her papers into the original common law courts of this land.
Exactly what she was doing. That's exactly what happened.
Yeah, it's not just the envelope.
That's the major thing she's doing, but there's 2 other things that are happening. She's creating a witness to the proceeding, the postmaster. And the second thing she's doing is she's setting them up for interfering with delivery of mail, which is a felony. And they know that.
Exactly.
Okay.
Exactly. And that's a good practice to do. If everybody on the call now, you can see, you get that postal clerk to time, date, and stamp your mail for you. Hey, it's a far-gone conclusion that the courts is going to be in a jam where they got to accept the paperwork.
Okay. Well, that's good to know. I'll definitely have to pass that information along to other people here. So.
Wow, I should have done that before I mailed in my letter.
I was talking to a man in Chile last year who was explaining to me something that I had never heard before. He was saying that when you go into the courts and you put in paperwork, they don't have to accept it because you're trying to enter things into the public, and the judge has the right to accept it, refuse it, the clerk also. And for people who have that problem, he said that when you go into the county recorder's office and file your paperwork there and get a certified copy, then what you have is the paperwork itself is the vessel, and the contents of the paper, the words that are on the paper, is the cargo. And so you have to bring your paperwork into the court with like the county recorder's office. The county recorder's office acts as the customs office for the contents of the ship, the thing you're bringing into the public. And it was really strange, and I never really caught on to what he was talking about. I kind of understood it. I never followed up on it, but I'm very interested in knowing if what Barbara is doing is a similar process.
Well, I'm quite sure that people will definitely be able to test that process when they know they want documents into the courts and they want documents recorded. Just go ahead at post office, stamp your paperwork, and send it off and see what happens. Because when you think about it, a lot of this is definitely trial and error, and it's away from your legalese guru. It's away from you getting away from legalese statutes and codes. So quite naturally, everything that you're doing is a trial and error on really finding out just how the courts look at certain documents that you're sending, and really just how the courts look at you as addressing yourself as a man, woman, and property, because all this is new territory for people that's seeing how they respond to things that you say and do when you keep it away from legalese. Because you see, they're definitely responding and they're acting different when you keep things away from the legalese in their jurisdiction. Now, to me, what I've been seeing is that they are definitely doing a lot of running. When you speak property and when you speak of man and woman, they're running. It's just that simple. I've seen letters being written back, and they are hiding and trying to get away from, you addressing them as a man and a woman. And if you notice, officers, police officers, they don't want to give up their first name. They don't want to give it up. Young lady, officer came to try to put her out of she asked for his first name and everything else, and he didn't want to give it to her, and he left her alone.
Larry, I want to share this because I think it's really relative to what we're talking about, particularly what I think the woman's name was Barbara was just talking about. I just got a 2-page letter from the Department of Justice, and it's their weak-kneed, silly response to 2 lawsuits that I filed against their little buddies. And, if you study it and you read it, you realize how little they have to work with. It's so, I guess the point that I would want to make is that they talked about the wrong court name and the wrong entity. In other words, they're talking about a name that's not my name, and they're talking about a court name that has nothing to do with my lawsuit. That's the best they can come up with. So my point is, so that's kind of reassuring. When supposedly the smartest legal minds in the business, that's all they can come up with.
Yeah.
If I had that happen to me, let's say their little letter to the clerk on my lawsuit caused me a little problem, a question that I would immediately ask and by the way, I learned never to deal with the clerks. You only deal with the head clerk, which Karl calls the court clerk, because he knows what's going on. He's been around forever. Judges come and go. Clerks are there 20, 30, 40 years. But a question that I would use is I would say, isn't it obstructing delivery of mail when I'm trying to deliver mail to the Doe court? See, you're not delivering mail to their court. You got to remember that. It's a mindset. You're delivering mail to your court.
Right.
All they are, by the way, the post office, Larry probably knows it, the post office has a whole procedure for using private people to help them when they're in like crunch time, like at Christmas time and Hanukkah and Easter. They'll bring in subcontractors that don't take the oath, they don't go through the normal process just because they're so desperate for an extra set of hands. So these people become part of the chain. They become part of the delivery chain of your mail. So that's like a real powerful question that I believe you could use effectively. I haven't done it, but believe me, I'll pull that question out real fast if I need to.
And Mike, you just made me think about something because you are so correct. When we used to hire contractors to make sure that delivery of that mail got through, and then at all costs it had to get through. So. That would be a good thing to ask. Are you trying to hinder, the delivery of mail that I'm trying to get to the court?
Yeah, but what I'm saying, Larry, is as an add-on to that that's equally important is they're trying to see if you know what you're doing. If you think you're delivering mail to their court, then they might have a little bit of say on it. Really, no, but they might test you. But once you make it clear you're delivering mail to your court, not their court, that's a whole different level that you're playing on.
You're stopping me from delivering mail to my court.
Right. What authority do you have to obstruct mail that's being delivered to the Smith court?
Yeah.
And is it going to be necessary for me to report this fraudulent activity to the postmaster?
Yep, to the post inspectors. Yep, you're so correct. I'm taking notes, so I got to take notes on just that right along. When you're having trouble with these clerks, you're right. Get the head clerk and just let her know, hey, whether you got to go get your attorney, office attorney, whatever, you just let them know, hey, someone is instructing, me from, getting this mail to this court here, to my court,
I've just had such good results pulling that card out. And when I was in family court, all I did was send a blank form of the mail fraud form.
Yeah.
Said, is it your intent? I didn't know all Karl's words back then, but I said, is it your intent to obstruct delivery of paid mail from the post office? I didn't say from the United States Postal Service, from the post office.
Yeah,
that was it. Never blocked me again.
Yeah, it's definitely different from the post office to the United States Postal Service. It's a difference. So people have to understand that difference, and the difference is it's the post office.
Well, Gus will know this better than me, but I'm pretty sure the Constitution refers to it as the original seat of government. And another interesting thing about the post office is if you look at all their forms, so you've got certified mail, you've got express mail, you've got certificate of mailing, which is a nice tool, all these different forms that you can fill out, they all refer to the USPS. There's only one that refers to the post office, only one.
Yeah.
That's registered mail.
Yeah, and that's why registered mail is always hidden under lock and key.
Yep.
And it's not that more expensive than express mail, but it's always under lock and key.
It's $12. $12 to send a letter, and you can go back 2 or 3 days later, and you can go to the postal clerk and say, I want a certified copy of the log of everybody whose hand touched that mail, and they'll give it to you.
And people get fired behind that registered mail. But any other, and you're right, the U.S. Postal Service and then that registered mail, post office, period. So, and the post office is one of the strongest. It's been around forever. So, and there's a distinct difference when you say post office compared to saying the U.S. Postal Service. So you mentioned post office to any government official, any court official. When you say post office, they know what you're saying instead of United States Postal Service. So you might want to keep that in mind also, But that really brings back some. But Barbara, I hope we answered, part of your question. Do you have another question, or you had any other thing
well,
you would?
I did have one more. Well, actually, I have a couple more questions, but one more that kind.
Go ahead. Yeah, we got time. Go ahead.
The one thing that I'm thinking of is I'm wondering how the Attorney General was able to get a court date in my claim when the affidavit of service was returned to me stating that it wasn't following civil procedure rules. And I know that the other person just previous to that had said that because it was an affidavit of service, that's why it got returned. But that would have been following their civil procedure rules. So I'm wondering how that got returned to me, and then the Attorney General was able to step in and go ahead and I know they can do anything they want anyways because it's their forum. But I'm just wondering how he was able to get a court date in my claim when I wasn't even able to get a court date in my claim. Anybody have any ideas on that one?
Well, you kind of mentioned a bunch of things there. There's some different things going on there.
Okay.
First off, in your claim, they're not getting a court date in your claim. If they're going to get a court date in anything, it's your lawsuit, not your claim. That's an important distinction. Secondly, I would say they're not getting a court date in your lawsuit because you are the prosecutor. And the prosecutor goes to the clerk and says, this is what I need. He's not the prosecutor, so if he's getting any kind of court date, it's in something outside of your court. It's in probably their civil court, but it's not your court. But, these distinctions are important because they help you with your mindset, which helps you with how you're going to react.
That makes sense. That makes sense to me because that was the other thing I was wondering too. Because our court date is on September 2nd, and I was wondering if when I appear, is he going to be the one that's actually prosecuting this thing or being kind of the prosecutor, or am I going to be walking in my claim and he's going to be trying to take over my court? So that makes sense that this is setting up his court, not my court, right?
Right. Right. You paid the filing fee.
Right.
By the way, this goes back to our discussion on property, which is very, very important, is that case is your property.
Hang on just a second, John. Before I go, you said earlier you talked to the clerk and you said this is what I need. Change that word need to require.
Right.
Yeah, I did do that, actually. I'm sorry, it's just kind of force of habit sometimes, but when I walk into the courthouse, I always say I require. I walked up to her, I said I require a court date because I didn't realize that according to their civil procedure rules, you have to make a motion to be able to get a court date. So I thought that I would just walk in there with that affidavit of service and state that I required a court date in my case.
Well, wait a minute. I think we're missing something here. As far as 21 days is up, then you get a court date after you service. Did that already go through?
No, actually it hadn't. What happened was
you didn't give him time. You didn't give him time to answer then.
Okay, that's what I understood as well, because when I first walked in, I thought that once she was served, that I would be able to get a court date, like let's say 21 days or whatever down the road, because here it's actually 15, not 21. But and she said, oh no, we have to see if all of your paperwork complies with whatever, and we have to wait for a response from the other side, and then you'll have to make a motion to see the judge. And I knew that part was incorrect, but I just kind of let her go with that. So I said, okay, well, I'll wait. So I ended up leaving the affidavit of service there with her. It got mailed back to me within a week, stating that it wasn't following civil procedure rules. And then within the probably the 13th or 14th day of her the worker having been served, is when I got served with paperwork from the Attorney General, telling me that we were having a date on September 2nd.
Yeah, you got things going on there. Mark, go ahead.
No, this is Gus. It sounds like the same thing that's going on with your case, John, where you had the man served and then the Attorney General's trying to step in, or the DOJ's trying to step in. So, Barbara, you had a man served. The man has not yet returned an answer to your claim, and now somebody's interfering. Some third-party interlopers coming in and saying that they're going to take over.
Right.
Yeah. So, on what day was the man served? Was it in July or in June?
It was in June.
Way back in June. All right.
Yeah.
So what you can do is the affidavit of service is what you received from the process server?
Exactly. And then once I dropped it off at the courthouse, I realized that I should have done actually, when they returned it back to me saying that it wasn't following proper civil procedure rules, I ended up doing up the notice like what Karl had done for his process server, and I also got it date stamped at the post office, and it never came back. So it is in the file as far as I'm aware of at the courthouse.
I would recommend you go down to the courthouse with a notice to the clerk and bring your affidavit of service, record it into your case file, give the clerk notice that the man has been served to the satisfaction of your court. Your last name is Lawson?
Yep.
Is that the name of the court, the Lawson Court?
Yep.
Okay, so, dear Luann, or whatever the woman's name is, greetings. I require you to record in my case or in this case, in case number such and such, the affidavit of service served upon Bob Richards or whatever the man's name is. Please know that the man has been served according to the requirements of the Lawson Court. I now require you to set a trial date sometime in the second week of August or sometime in the third week of August. Please let me know what that date is as soon as possible. And that's it.
Okay.
Just let her know what her job is because, and it gives you an opportunity to reiterate that it's the Lawson Court and it's not the rules that she's used to working with. And if she has any questions, please first check with your chief judge. And if he doesn't satisfy your curiosity, then I'll be happy to help you out. Something to that effect.
Okay, that sounds good. Because that's what I was thinking that I should be doing is I was just in the process of doing up the orders, similar to the way that they have it in their civil procedure rules, except that it has the Lawson Court at the top and the prosecutor with the line in between and the wrongdoer, and that I order the court to whatever because I wasn't quite sure about having to put an order in, and that was one of the things that...
Actually, I overlooked something. The man has been served, however, he has not answered the claim. So go down to the courthouse and make sure that the process service was recorded into the case. If not, get that done and over with. And let the clerk know that you have the right to have a final decision, that you will not settle for a default judgment. That and you're going to want to do this in writing. But you need the man brought in. You need to issue a warrant or a capias or whatever it's called where you're at, and
right.
have the man brought in to answer this claim. He has to be given due process, the opportunity to answer the claim before you can get final judgment.
Okay.
My opinion is I would also put in at least 2 notices. I'd put in a notice of interference. You can take a look at Karl's version. Did you download all of Karl's documents?
No, but I can look for it.
Yeah, it's real simple. It just talks about any court employee who interferes with my right to,
I remember seeing that one.
Yeah. So I think that's crucial. I have that in my case, and I think that's one of the reasons that tippy toeing. The other one I put in there that I made up myself, but I feel real strong that it was the right thing to do, is I put in a notice : property. And I just basically said this case is solely my property.
Okay.
And so they know they have to protect the property of man, in your case, woman. And so this Attorney General has come along. He's now trespassing on your case. And if he causes any harm or damage and the court is aiding that in any way, you get to write them a letter saying not only are they interfering with my rights, they're also robbing me of my property.
Okay.
Because the case is your property.
Right. Well, I'm glad I called in.
But the notice interference, I'd have that in real soon, especially with what's going on.
Oh, definitely. It'll be in there.
I believe, if I remember the story correctly, some of the guys on the phone might remember it better than me. I think Karl filed that after they did some kind of motion to dismiss on him.
Right.
So not that you're waiting for that, but I mean, anything that they're doing to trespass on your case is certainly, if not sooner, the time to get your notice interference in there.
Well, actually, it's funny that you bring that up because the Attorney General, the paperwork that I got served by him, it states that he's looking for either a summary judgment or to have the case dismissed for abuse of the process.
Well, yeah, what they're doing is the same thing they're doing in my case. They're trying to save the ass of their buddy.
Yeah.
Yeah, that's all that's going on there. So what they're doing is they're testing you. They're trying to see what you know, and they're testing your mettle.
Okay.
So the court...
And one thing that they're doing real quick is that when you call their buddies out, they're running to the judges real quick for help. And that's what they're doing, trying to get their buddies to help them, trying trying to get their brothers to help them. So that's what they're doing. So now they're trying to see if you know what you're doing. You know,
right.
so, yeah. So that's some good advice you have gotten so far that, you know, and these guys that's giving you this advice is guys that are students, you know, of what Karl would, you know, tell you, and I'm quite sure they're listening on the show, and any corrections that has to be made when he comes on, he probably will, you know, make some corrections from what he have heard and everything else. But for the most part, all the guys that's been giving you some assistance, you know, it seems like they're on point to what Karl's process has been. So,
right.
And you said you had another question.
Well, my one last question is that so far I've been very unsuccessful in getting the courthouse to really do anything for me. Let's say I do walk in on September 2nd in their case. How exactly do I handle it? Like, I know that I would walk in and state that I'm here, or not that I'm here, but I'm there commonly called, and that my claim is, and to stand on that claim, especially if they try and get jurisdiction over me 3 times, repeat the claim. How would I handle the Attorney General? Is
the court hearing that's scheduled for July for September 2nd? That is a hearing that is scheduled in the case with your case number on it. It's your case.
Yes. Then
the court would open up. You're the moving party, so you would state your claim. And if anybody except the man, if anyone except the man, the accused, speaks up, then object and tell them that you've got no business being in this court. You're interfering, and you're a trespasser. Would you like to be a party to this case? Because I'll be happy to include you, or I can benefit you with your own case if you'd like. But you've got no business being in this case, interfering with my right to pursue my claim against this man.
Right. What I was thinking of was saying that is that man trying to make a claim for my property?
If you want to get right to the point, ask them if they have any first-hand knowledge regarding the claim you've made. And they're going to have to admit they don't have any first-hand knowledge. And thank you for showing up. You can go home now.
Okay. All right.
Get that notice interference in there.
Definitely. I will do that.
That date might not even happen if you put that in there.
Okay.
You definitely want to follow what John's talking about with the notices. You need to let everyone know who you are, where you stand, what the rules are as you go along. As somebody trespasses, you want to correct them. And, mostly the clerk needs to be aware that this is not a case in that local court, that this is the Lawson court, and this is a case in the Lawson court, and that she is, I don't know if John mentioned this, but you're going to need to appoint the clerk as your clerk. And John and I were talking last night about possibly sending a letter to the clerk, asking the clerk which magistrate she recommends because of their ability to discern common law, or something to that effect. We were talking about writing a letter to the clerk that's appointed in John's case, and asking that clerk to recommend 3 magistrates based on their experience in common law. And these kinds of communications are things that you do to make everyone aware that you're moving forward according to the way you wish to move forward with your case in your court, and that you're not subjecting yourself to their rules.
Right.
Another thing, I didn't think of this earlier, but you should see, I've done all this, so I'm kind of taking it for granted. I got about 8 notices filed into my case. They're just real basic things.
Yeah.
But I have a notice jurisdiction filed into my case, which I think is very important.
Yeah.
Take a look at Karl's, how Karl did his. Of course, his was federal, but most of that applies to state. And notice venue.
Right.
Your court is the Lawson court. It's in the Lawson court, but the notice venue is going to say it's at, the various names that they use. And they know what that means.
Right.
So what you're doing is you're building a set of walls that they can't go around. Right now you have no walls up. So they're just in this open field and they're going to run around.
Yeah. I've done the notice of venue. I've done the notice of
hey guys,
jurisdiction.
can I interrupt real quick? John, it sounds like you're talking about putting billboards up in your front yard before they do anything wrong.
Right.
You don't want to do that.
Okay. Well, I've already done it in mine.
Well, I know, but that was the analogy of what you did. You just put up a whole bunch of billboards saying, "Don't touch my grass, don't look at my shrubs," and I don't know.
No. Wait a minute. Let me jump in there. None of it says don't do anything. It's defining. I'm defining. In other words, I'm defining the venue. I'm defining who the wrongdoer is. I'm defining.
Shouldn't that be on your claim, though? Shouldn't that be on the?
Yes, it is on the claim, and
it's written all on there. Okay, go ahead.
Mark's correct. This is something we did discuss. You want to address only the specific thing that has just come up. You don't want to put anything into the future. You don't want to say, well, they might do this, I'm going to put in this notice. They might do that, I'm going to put in this notice. What you want to do is you want to have all these things figured out as best you can, and when they do trespass, when they do something that you need to address, you've already given it lots of thought, and now you can do something immediately, which shows them that you're prepared. You're not just somebody who's winging it. You've given this a lot of thought. You're possibly hooked up with a team of people on Skype and exchanging messages and ideas. All week long. I mean, Mike's got a call on Tuesday night. Sonia's got a call on Friday. I've got mine on Wednesdays. So, this can be a really fast, quickly resolved issue if you haven't given it enough thought to a particular situation. But by addressing them as they come up, not ahead of time, you're showing them that you're on top of your game. So just address what needs to be addressed. Like John said, with a notice, you give them notice of a particular thing, but only that thing which you need to give them notice of at this time. There's no need to give them advanced warning of anything.
Okay.
So with that said, Gus, what has transpired already? Would you feel, and would Mark agree that the notice interference and maybe notice property are appropriate now?
Well, there's only one thing that's happened. Somebody's trespassed on the case, and the man has yet to answer the claim. So, I would write to the clerk, Dear Luann, greetings. The man has not yet answered the claim. I'm not sure who this other entity is, but they are not a party to this claim, and they are trespassing on my case. It is, I require and authorize you to remove whatever trespass is on, whatever this paperwork is from this case. And I would do that when I show up in the next few days. I mean, if she had this guy served in June, it's time to drag his ass into court and get this, going. There's no reason to wait any further. I don't know how to do that. I don't know how to do the warrant. I don't know how to do a capias or what the proper process is yet on bringing the man in, but I have the right to a final judgment in my case. And so that final judgment will not be final unless the man is there to hear me state my claim against him, and until he's afforded due process, I can never get a final judgment. So the court of record is, it's that common law due process that he has a right to. So he has to come in and face his accuser, be given the chance to speak, and if he chooses to remain silent, that's completely fine. But the only way to get him in there is to issue a warrant and to drag him in. So at this point, there's two things going on. One, the man has not filed, he's ignored the claim, which is what we've seen repeatedly, and we need to figure out how to bring the man in. Meanwhile, there's an interloper, somebody trying to interfere with the court, with your court, and that needs to be put to an end, and that can be done by writing a notice to the clerk that she's allowing someone to trespass on the case. She should know better.
Okay. I will definitely do that for Monday morning then.
Yeah, and guest 17 says handwritten letters only. You are doing everything.
Yes.
Yeah. Man-made. Everything has to be man-made.
And do you know the name of the judge that is trying to interfere into your case?
Not so much the judge, but the Attorney General. I know the name of him.
Yes, okay, that's from the Attorney General. So it's the Attorney General is interfering. So if you know his name, then you just you undress him, call him out, and let him know he's interfering with your interfering with your case.
Okay. All right, that's what I will do. Thank you very much.
Hey Larry, the Attorney General, whoever it is somebody who's interfering with the case. Yeah, I guess you could write to him and just let him know.
You're giving him a notice. You're giving him a notice that he's interfering.
Who was the one that signed the paper?
That's what she's guessing.
I'm guessing the Attorney General didn't sign that paper. Who actually signed it?
It was a man that signed it. Bob.
Okay, is Bob acting as the Attorney General?
Yes.
Okay, that's who you write it to. You write your notice to Bob.
Okay.
Hey, I got a question.
Go ahead.
Is this similar to somebody trying to put cargo on your vessel, and you don't want that cargo on your vessel? Because you were speaking about paperwork being your vessel, and the words on your paper being the cargo. So you're storing your vessel in your court, and somebody comes in and tries to put cargo on your vessel. I'm just trying to make an analogy here that came to me because you guys were talking cargo and vessel earlier, and it sounds like it fits. I don't know.
Well, it's your case, and nobody should be allowed to take a dump in your case.
And that's the key right there. It's her case. So just tell him you need to get out. You need to get out your case. You don't know what you didn't invite him in.
Yeah, go start your own case.
Yeah. Now let him know. Now me myself, I would write him to let him. If you want to get involved in this case, you can pay your way in. Pay me. $500,000, $25,000. You can become a part of the case. But other than that, if you can't pay your way in, get out.
Right. Well, that's the other thing. When I got the service there for the September 2nd court date, I was pretty ticked because this is my case. I paid for it. And here he jumped in and started getting a court date in my case. So that really...
I got it. Would a good question to the Attorney General is, are you offering me legal advice? Maybe?
Well, you can ask him a whole lot of things since it's not his case, but I think you might want to just simple it down and just make it quick and strict and straight to the point and simple to him. Letting him know, that it is your case and just go ahead and let him know he's trespassing on your case and that you require that he cease and desist.
Yeah, dear Bob, your attempt to trespass on my case does not please the court. Does not amuse the court.
Yeah, that's a good one.
Cease and desist.
That's a good one right there. That's it right there.
Period.
Yeah. And this call is being recorded, so you can come back and listen to it and get some of the answers that you got. But that's a good one right there. Gus just said right there. That's exactly. Really all that needs to be said, and let him answer. Yeah.
That sounds good.
What Gus mentioned earlier was for you to go ahead and write the clerk and let her know about your court and when you want to schedule a date with her to schedule a date with for your court, not to let some attorney general decide what your court is.
Well, first thing is to bring the man in to answer the claim.
Right. So I require a court date.
Well, you require the court to issue a warrant for the man to be brought in to answer the claim. And this is the problem is, like I said, I don't know how to handle this yet. But if I put a claim in, I have a right to a final judgment. That final judgment's only going to happen when the man accused has a chance to face me, his accuser. at that time, if he chooses to remain silent, it's fine. And I can get a final judgment because he was afforded due process. However, until that man shows up, my case goes nowhere. So how do you get the man in? Do you show up at the court with your lunch and your coffee in your hand and say, the man was exceeded his time limit, I'm going to sit here while you issue a warrant, I want him brought in today. And just, park yourself right in front of the window and just wait. What do you do? How do you get them to issue a warrant to bring the man in to answer your claim? Because, and when they do, what's going to happen? Are they going to say, well, we're going to issue the warrant, you can go home, and when we find him, we'll call you, and you can have court the next day? How does this whole process work? So I'm a little fuzzy on that. I got to do some research on that, hoping to run across some people who've done something like this before to get some insight. But this is where we're at right now with John and Terry in Ontario, in Toronto. It's the same thing. And I believe that whenever we do file a claim, that I know if I got a claim from some man and I didn't know what to do with it, and I went to my attorney, which is what most people do, their attorney would say, just ignore it. They don't know what they're doing.
Right.
So it's a really good defense on the part of the accused to ignore the claimant, because if the claimant does not know what to do next, then nothing's ever going to come out of it.
Yes, so you either have to do one or two things. Have a warrant rest for him, or drag his behind in court with a subpoena. One of the two.
Well, a subpoena can only be issued if there's a hearing. So if there's a hearing scheduled, then you would issue a subpoena for that hearing.
That's what she's heading toward. Isn't that what it's her court? So,
but I don't know if you can schedule that hearing before the man answers the court, before he answers the claim.
Well, let me ask you this, because when you're talking about put a warrant for his arrest just on to come in and answer a question or a claim, I think you have to connect those. You'd have to connect the dots on that. When do you drag them in? Do you drag them in before your court hearing, or do you drag them in? Cause to put a warrant on someone, it has to show. It has to be warrant to put that warrant out there on it. And I don't think putting a warrant out on just because somebody don't answer your claim. In other words, most claims, if you don't answer, the person that normally files the claim normally win the claim.
I think from what I've understood from what Karl has said so far is that you give the person or the man or the woman a chance to appear in court first. And if they don't appear, that's when you ask to have a summons issued for that person.
That's what I was saying. A summons has to be in some kind of way before, because you give it due process. And when you give due process, I'm quite sure it has to be put in that some kind of way. So, and you're right that what you just stated is, on line of what probably would have to happen, that give that person X amount of time. But like Gus said, it all depends on, do you get your court date set up? Do you do it before? I'm quite sure you have to do it, right around the time you're getting your court date set up. That they drag them in the court once you get the court date,
Right.
I don't understand, Larry, but I can tell you what Karl told me on the phone. I remember pretty much verbatim. Is I give them 21 days. If they don't show up, I go down to the court and I have them arrested. Now, he didn't give me the mechanics of that.
Right. Okay, now that makes sense, though.
Now, if I can't get a hold of Karl and I can't figure out how to do that, I'm just going to trace my steps back on how they did it to me. They have a court form, and somebody has to declare under penalty of perjury that what's being requested, the arrest, is true and relative and all that good stuff. So I would just emulate that. But before I did, in my own handwritten format, but before I did all that, I'd make sure I had that notice interference in there, because I think that's foundational. Because if they obstruct me from getting my justice, which is the whole point of a claim, then they're trespassing on the case. I mean, that's just got such broad application.
Yeah. Good point.
But
Good point.
I think from what I've heard is that you go to the court clerk and you have her issue a summons.
Well, for now, my suggestion to you is the same to myself. I'm going to go and get their documents on how an arrest is done. I'm going to go on their website, then I'm going to read everything, then I'm going to go down to their court, I'm going to talk to the clerk and get as much information as I can so I see how they see things. Because that has some value. Yeah, it's our court, we're going to do what we want. But anywhere there's an opportunity to match their paradigm in a way that doesn't jeopardize our goal is not a bad thing. You know, if you're always going in there and shocking them with this completely different perpendicular way of doing things, you know, your life's going to be harder than necessary.
Say, Mike, so, you gonna be on your show Tuesday?
Yes.
You gonna have that on the? You gonna have that? You think you have the answer to that? To how you set an arrest on your show Tuesday?
I don't know. We can get a bunch of people working on it. Yeah, if there's something important or something is in a rush, I'll start a show anytime.
Well, I was wanting to make sure Barbara have a way of, you know, communicating with this same particular topic. If she get on your show Tuesday night and you know you have some interesting information to share with her on that particular topic of how you set up a warrant, get the court clerk to do this, since you and her have some of the same issues and everything, you know.
Mm-hmm.
That way she can just come on your show and y'all can just share that information on the show.
That sounds good.
What I did in my case, for what it's worth, I did a notice property, and in that I did the document just said this case and all of its contents are my property, solely my property. You know, if I had it to do over again, I might have even put a compared to as an exhibit, which would be a bill of lading, because those people are very familiar with bill of lading. The bill of lading is a detailed list of the shipment of goods. And that's what Gus was talking about earlier. That concept's been around for 1,000 years. That goes way back to Roman civil law. These guys know they cannot interfere with private shipment of cargo. That's a big, big no-no. It's just like it's a big no-no or analogous to they can't touch your property.